Hi everyone, welcome to today's lecture on Chapter 14 in regards to legal aspects of sports marketing. Today we really talk about issues that come up when it comes to sports marketing and the law. Because if we are going to be opening our own business, if we are going to be working with a major company, we have to understand that there is a certain side of sports marketing that risks a host of legal consequences. So what our chapter today goes over is some general concepts, practical issues that are most relevant to sports marketers. And also we need to recognize that a lot of these legal issues are very complex, and they really do require assistance beyond our own expertise. So this degree is not to prepare you for a career in the law, but some of our classes and some of our lectures, like today's lecture, hope to expose you to kind of the legal side of things, to educate you to be prepared to seek assistance when it is that time. So some objectives that we're going to cover today: we're going to introduce key legal concepts and issues that affect the marketing of the sports product. We're also going to inform sports marketers about the need and the methods used to protect intellectual property associated with the creation of a sports product or event, or with ideas developed out of sports sponsorship and licensing programs. And then, like I said, we're also going to examine the legal limits of sports marketing and promotion so that sports marketers, entrepreneurs, can better manage risks to avoid legal liability. And here's basically the reason, the why for this chapter, is because if we don't have some sort of working knowledge of how the law really affects sports marketing, you could really put yourself at considerable legal risk. We probably have a good idea that the law is very complex, and sports marketers really require assistance from trained lawyers to navigate issues. One of the benefits to this type of class, even though it isn't necessarily exercise science related, is that it exposes you to maybe some ideas and concepts of what you would be responsible for if you do open up your own business in the sports medicine or the fitness technology arena. So I want you to understand that there will be a certain point where you need to seek assistance from trained lawyers. If you work with a company, you're probably going to have some lawyers that are hired there that work for the company that you can seek out their assistance. If you open up your own personal business, you might want to establish certain relationships early on, whether it's hiring some sort of legal advice to protect yourself, or whether it's to seek advice when the time comes. But the goal of today's lecture is really to help you have a basic understanding of key issues. Most of this chapter focuses on intellectual property, specifically three areas that you see here. Most of the lecture today talks about trademarks. We'll also get into copyrights and patents. The goal of intellectual property laws are to reward the invention and the ingenuity and creativity in an effort to maintain an open and competitive marketplace. And really, to encourage that type of progress, whether it's in the science or the arts, the framers of the Constitution wanted to give Congress the power to protect the intellectual property rights, so that they could have exclusive rights to their writings or their discoveries or the products they created. So anyone that has some sort of intellectual property should be entitled to capitalize on it as long as they're not infringing on the prior rights of others. So we really start getting into the first section of the chapter that talks about trademark law, and this is kind of the area of greatest relevance to sport marketers. And we want to also look at copyrights and patent laws and things of that nature, because I'm sure you guys have seen the C logo for the copyright, the TM for the trademark, and the R for the patent. And we really need to understand what those differences are because of several different reasons. First and foremost, because of timelines involved. Trademarks can last forever, and some have, like copyrights and patents have certain time limits. Also, individuals could be permitted to use something that's been patented, trademarked, or copyright, but for a certain fee, and that's called licensing. So I want to take an opportunity within this chapter to kind of clarify those differences so you have a basic understanding, again, so when the time comes, you're able to seek assistance to protect your own business or to protect the job that you're working at. Let's talk about licensing first, because licensing is kind of an umbrella that protects trademark, copyrights, or patent owners. And this is an opportunity where those type of owners grant permission for its use to others for a fee. And when another doesn't have permission, or in other words, license rights to use the copyright, trademark, or patent, then that person is said to be infringing on the rights of the intellectual property owner. If you look at your textbook on page 399, you see a really good example of licensing and actually trademark law that's taking place. So I'm going to go ahead and skip over to the next slide, because a trademark is a word, a name, a symbol, or even a product or a device used by a person, generally a manufacturer or some sort of merchant, to identify and distinguish its goods from those manufactured and sold by others, and also to indicate the source of the goods. So if you look at the picture on page 399, you can see that the trademarks on this page protect the Chicago Cubs and the Wilson logos, which you can see those on the player's sleeve, the New Era logo, which is on the cap, and then also the Rawlings logo, which is on the glove. And if you think about it, it makes sense, because there's lots of different glove makers out there. There's lots of different ball caps that are made, and New Era and Rawlings specifically in this example are serving to identify the source of their origin. They're also trying to protect consumers from confusion or deception, because another part of having a trademark law is to really designate a consistent level of quality, to represent any sort of goodwill of the owner's products or services, and then also to signify a substantial advertising investment. So once you have a product that you want to trademark, how do you do it? What you can do is apply for a trademark with the United States Patent and Trademark Office, and this is considered a federal trademark. In situations where a federal trademark might not be necessary, there's also protection afforded under various state statutes that have their own private protection, similar to something that's provided in the Lanham Act. But it was kind of enacted in 1946. Lots of really important benefits to having something trademarked, and those are listed for you on page 400. And this is important because, unlike copyrights and patents, trademarks can last indefinitely as long as the trademark owner continues to use the trademark in commerce. And when creating a new trademark, have I been saying trademark? Trademark. When creating a new trademark, especially for those of you that are considering opening your own business and having some sort of logo associated with your business, it's really important for you to do your research prior to even applying. You want to see what's already out there in the market. So you can do this in a couple different ways. I really recommend actually hiring an intellectual property counsel to actually conduct the search themselves. It's a couple $100. The work is on them. They do the search. They report to you and let you know if anything is flagged or comes up similar to something that you've created. If you're not in a situation where you can afford to hire an intellectual property counsel advisor, then what you can do is you can go search. A U.S. government has a free database. It's www.uspto.gov, and you can perform the search yourself. If you hear anything out of this class, one of the things I want you to be able to take away is what you can do to protect your business, your product, if you decide to take that route upon graduation. And this is a very important step. So whenever we have class projects, whenever we have activities or labs in class where you're asked to create a logo for your own business, I would practice going through the steps, going to that website. The website is actually also listed for you in your textbook at the top of page 400 in the right-hand column. Take an opportunity to search through there and really decide for yourself if it would be worth your time to either hire someone or perform that search on your own. Okay, so let's talk about the different types of trademarks, there I go again, and really understand what marks can be protected. So we've got different types listed here for you. We've got trade dress, which protects kind of the product packaging, a service mark, which talks about the service versus tangible products, and then a collective mark, and this is the names and logos associated with players' associations and leagues. And again, if you want to reap the benefits of being protected, you have to be registered under the Lanham Act with the USPTO. So why is this important? What does it do for someone that's been registered? You have the ability to be able to sue in federal court if someone decides to copy what you've done. You also have the ability to obtain trademark registration also in foreign countries, which is a little interesting. You also have the opportunity to file the trademark with the U.S. Customs Service to prevent the importation of infringing foreign goods. So if you notice something's being imported in, you can take issue with that, and you can also take legal action. You also have acknowledgement and protection of the goodwill of the trademark holder and the provision of public notice throughout the nation of trademark ownership, which basically makes it an easier burden of proof in trademark infringement lawsuits. So it really is in the best interest of someone creating a new product, creating a new device, to get it either federally registered in the trademark office or through the local state statutes. And I clicked forward too fast, so let me back up for a second. Here are the last couple ones that I'd mentioned, but didn't click forward on. Sorry about that. Take an opportunity to read through it if you need to. But I'm going to keep going on now, talking about the different types of trademarks, talking about what's difficult to protect and what is easier to protect. So your book talks about 3 different types of trademarks. You got your fanciful or your distinctive trademarks that typically are something like the name of a team, the name of an event, or the name of a product. So think about all these minor league sports teams that are popping up in baseball, all of the new MLS teams that are branching out. Minnesota just got a new expansion team. Orlando City is recently new within the past 3 years. Those types of names are relatively easy to protect. Arbitrary marks aren't necessarily as distinctive as the fanciful marks. They're typically words or names or symbols that are commonly known but have also become associated with a particular product. So think about arena football, or the Arena Football League, or Field Turf. It's a particular product, and those words are known with a particular product. The last category of distinctive marks is called suggestive marks, and these kind of note something about the product, but it doesn't actually describe a specific quality or specific characteristic or even a specific product or service. So think of the companies like Nike. What do you think about when you think of Nike? You probably think of really hardworking athletes. Someone's probably sweating, working out, things of those nature. Another good example is Powerade. It's typically their sports drink, but now they've branched out to doing protein bars, supplements, powders, and you kind of have an idea about the company of Powerade, but it's not generated around one specific product. You've also got descriptive and generic types of trademarks. Descriptives are very, very difficult. They're not impossible to protect, but they're not as easy. And that's because they don't distinguish one product or service from another and typically use common words in ordinary spelling and meaning. Generic is also a commonly used word or phrase, and it's very, very difficult to protect, so there's never usually entitled to trademark protection. The next item your book talks about is secondary meaning. Secondary meaning is basically someone producing a product specifically with colors that are exactly like a professional sports team, but just simply omitting the logo. So your textbook defines it as a mental recognition in buyers and potential buyers' mind. The products connected with the symbol or device emanate from or are associated with the same source. So think about FSU jerseys. Have you guys ever been out shopping in a Dick's sporting goods store or a former Sport Authority store and seen something that has FSU colors but just didn't have a logo on it? That would be something that implies secondary meaning. One of the earliest cases that involved a lawsuit with secondary meaning was with the Seattle Seahawks. They sued an apparel manufacturer who was producing a football-style jersey in Seahawks colors, and again, they left out the Seahawks logo. The court actually held that the Seahawks color scheme on a football jersey had acquired secondary meaning, which entitled the Seahawks to trademark protection over that particular use of the color scheme in those football jerseys. Your textbook goes into a couple other examples of secondary meaning, but basically it's any sort of manufacturer that's trying to maybe, what's the word I'm looking for? benefit from using something that looks similar to the real product. Let's talk about trademark infringement. And secondary meaning kind of leads us to this idea talking about trademark infringement. What's the difference between secondary meaning and trademark infringement? Trademark infringement is specifically counterfeiting, reproduction, or any sort of imitating a registered mark in an attempt to sell or advertise goods or services that are likely to cause confusion or deceive the trademark holder. And there's a few different types. The traditional trademark infringement, which is meant to confuse, to mistake, or to deceive. False designation of origin, and also dilution. And we'll talk about those in just a second. So how can we actually determine if there has been trademark infringement taken place? A couple different ways, a couple different things that federal or state authorities will really look at. They'll look at the strength of the trademark, the degree of similarity, the similarity of the products involved, the market channels, as well as the distribution channels involved. They'll look at the intent of the defendant in adopting the trademark. They'll also try and analyze the sophistication of the potential consumers, and they'll obviously look at the evidence of actual confusion. When can someone actually sue for trademark infringement? There are two types of situations that you can make a claim under the trademark owners have the ability to sue. The first one is false designation of origin. And under this theory, the owner of the trademark has to establish that the public recognizes that the trademark identifies the owner's goods and services. After they've done that, a plaintiff must then prove that a defendant's use of the trademark is likely to deceive or cause confusion within the public to make them think that their product was the original origin or service or goods. Dilution is otherwise known as blurring or tarnishment, and that's basically when someone takes a logo and keeps it very, very similar, but maybe just changes the wording. So a lot of times this is done when maybe a company, maybe your school, they're going on an event, they want to make t-shirts, and they're doing maybe a survivor theme, and instead of completely changing or creating their own logo. They take the Survivor logo and then they just simply change the wording maybe underneath the name of the logo. And it can occur by blurring where the defendant uses an identical or similar mark, but it impairs the distinctiveness of the plaintiff's famous mark. So your book gives you a couple different instances where that took place. Let's talk about next about defenses. When someone can claim that, look, we didn't make a trademark infringement. And the first one your book talks about is an abandonment. And under the Lanham Act, trademarks can be deemed abandoned when the trademark owner discontinues its use and doesn't intend to resume using the mark within a reasonable length of time. So when a sport property changes its name or its logo, but it wishes to retain ownership of previous marks, that particular company has to take precautionary steps to prevent abandonment of the marks. Typically, the steps include maintaining the mark's registration at the appropriate renewal periods and periodically using the old marks in some sort of manner. The fair use defense is allowed when someone wants to use another company's trademark in connection to their own, as long as the sale of your own goods or services is not deceptive in nature. So for an example, let's say that Adidas is running an advertisement for a brand new running shoe that they've created that's very similar to a Nike shoe that just came out. Adidas can use Nike's logo and brand in their advertisement as long as they're not attempting to deceive and simply compare. Another defense against trademark infringement is the idea of genericness. Now remember, one cannot obtain trademark protection for generic items, even through the acquisition of secondary meaning. So an alleged infringer can argue that the trademark in question has become generic. So because of this, leagues can't really claim to own terms like championship or the big game. And we also have to be very careful because we have examples like Kleenex, aspirin, trampoline, that were all at one point trademarked, but because they became so generic over time, that they've basically fallen into public domain. So the idea that a trademark can become generic points out the need for companies to really protect, but also to promote their trademarks very, very aggressively. The final defense against trademark infringement talks about functionality, and very simply put, this involves marks that do not describe or distinguish the product or service, but are necessary for the product to exist. Additional protection issues. One of them is called cyber squatting. Think about this. I think it's kind of a funny name. But basically what's happening is individuals will register domain names on the internet just for the sole purpose of forcing that particular company to have to buy that domain name off them. So think about Nike. Now, they've been around for a long time, but let's say that Nike had been around and the internet all of a sudden was up and coming. If I tried to establish www.nike.com, I'm not even sure if that's the right website, for the sole purpose of having Nike come to me and buy that domain name for me off of me, that's called cyber squatting. So that's an issue that's out there. Another issue is the fact that we're very much moving toward a global economy. We've got international trademark registration that is a little bit of an issue. And we're seeking to do a lot more business abroad. More information is on the internet, more commerce is transacted through the internet. So one of the ways that some countries kind of pooled together to protect each other's protection trademark issues was something called the Madrid Protocol. And this went into effect in 2003, and under this specific protocol, a U.S. trademark applicant is now able to file a single application with the U.S. PTO in order to obtain protection in all protocol member countries. So we've got some countries that banded together, about 60 of them, that agree to this policy so that people that are applying for trademarks don't have to do it through the United States government, the Spanish national government, the English national government, and so on and so forth. The next section of your book is moving on to talking about copyright law and sports marketing. So let's jump right in. Copyrights can protect written works, music, pictures, graphic designs, audiovisual work. This also includes broadcasts of sporting events. So there's two pieces of governmental legislation that protects. We've got the Copyright Act of 1976. This protects original works of authorship appearing in any tangible medium of expression. We also have the Digital Millennium Copyright Act, which provides copyright laws regarding the digital creations and the internet. So a copyright can be for something to be developed later, but the work has to be something that can perceived, it can be reproduced or otherwise communicated. And your book does a good job of laying out works of authorship that are protected. There's a big long list listed on page 408. I'm not going to read all these to you guys, but if you'd like to go through them, you can on your own. So when has something been infringed upon? A copyright infringement occurs when someone makes an unauthorized use of a copyrighted work. Courts look at a couple different factors when determining whether copyright infringement has occurred. They look at the purpose of the use, including whether such use is of a commercial nature or is it nonprofit for educational purposes. The courts will also look at the character or the nature of a copyrighted work. They'll analyze the amount and substantiality of the portion used in relation to the copyrighted work as a whole. In other words, did they just take a small portion of it, or did they use the entire item that was copyrighted? And the effect of use on the potential market for or value of the copyright work. So similar to looking at the trademark infringement, what are some defenses that someone might use if they're accused of copyright infringement? There's a couple different things. And they are criticism, comment, news reporting, teaching or educational use, scholarship and research. So what does all this mean? Basically means that a defendant can challenge the authenticity of a copyright. More commonly, a defendant can claim the defense of the fair use doctrine, which was originally created by the courts as a means of ensuring that creativity was not stifled through all these rigid enforcements of copyright laws. And the fair use doctrine has really kind of now been incorporated into the copyright Copyright Act. And this allows for the fair use of a copyrighted work when the use is for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. And then the courts also use the 4 factors stated earlier to determine whether the use made of the work falls within the fair use defense. The final section in regards to copyrights talks about sporting events that take place. Broadcast and cable television transmissions of sporting events are fully protected by copyright laws, but the events themselves, the games, also the statistics that come out of the game are not necessarily covered under copyright laws. So the question of whether these sporting events are copyrightable has really yet to be fully answered. So although an athletics competition itself might not be copyrightable, event organizers can take steps to protect their propriety interests in an event. Take, for example, ESPN. They used a trademark symbol. They created the Extreme Games, and they used the X symbol in securing trademark protection. They slapped it on all of their products. They took a distinctive trademark. They established long-term contracts with their participants. They also prohibited sponsors from creating or sponsoring similar competitive events. These types of steps can further protect event ideas. But again, the actual event itself, the game, it cannot be copyrightable. The tape, the video of it can be. I mean, you hear that all the time, at the end or the beginning of an NBA game, an NFL game, even March Madness. Good gracious, with all the sponsorships that's happening with March Madness, this telecast is a copyright of the National Football League. Any rebroadcast, transmission, or any other use or description or accounts of this telecast without the expressed written consent of the National Football League is prohibited. They can throw those on there because they are telecasted or a transmission, but the event itself, right now, is not copyrightable. The next section in your book talks about patents. Patents can be granted to anyone who invents or discovers new or useful processes, machines, manufactures, or composition of matter, or any new and useful improvement. They can't necessarily be granted for just an idea, only for the actual invention or complete description of it. And typically a patent will last 20 years. After a patent runs out, anyone can use the technology or make the product. If you decide to create your own business or to pursue a patent at some point in your career, it really, really is encouraged to understand the patent laws. It's very important, mostly because patent law can be the most complex of the 3 areas of intellectual property. And think about it this way. The ability of inventors to profit from their ingenuity is grounded in the protections under the patent law. Remember, you've got 20 years once you've been granted the patent to develop your product, as long as you're not cornering the market on it. So during those 20 years, the patent owner must not violate antitrust laws by virtue of having a patent. For example, limiting the licensing of the patent or using the patent to fix prices or restrain trade. But once that 20 years expire, anyone can make use of it, sell, create your patent. Think about this, though. Patents, specifically with sports players, should they have the capability of patenting a move within the game? You guys have all read The Sports Gene at this point in your educational career, and if you guys remember, they talked about Jim Fosbury, who was the inventor of the Fosbury flop. This was the revolutionary new way that he created of clearing the high bar instead of going basically chest forward, head over the bar. The Fosbury flop was a bended back first jump, and basically, could he have patented that move? Could that have prevented his competitors from using that technique? At this point, no one's been able to do that, but we wonder if it's only a matter of time. So again, if you're someone that's interested in pursuing a patent, do a lot of research yourself or hire individual counsel that can advise you appropriately to make sure you're protected. The next couple sections in your PowerPoint and out of your textbook are kind of smaller segments that they've kind of wrapped up into a bigger section for your chapter. So I'm going to touch upon them briefly, but as always, read, take notes very carefully, and ask questions if you have them when we're together in class. So the next small topic is on sports marketing communications, and this is the idea that sports marketers need to be aware that commercial communication which is usually in the form of advertising, can be restricted by federal law. So the commercial speech must concern a lawful activity, must not be misleading. The state must have a substantial interest in the restriction of the speech if it's necessary. The regulation must directly advance the state's interest, and the regulation must also be no more extensive than necessary to meet the state's interest. So this is basically protecting the communication that's being put on the market. Sorry, forgot to click ahead. The next small topic talks about ambush marketing in sports marketing, and this typically occurs when a company capitalizes on the goodwill of an event by using tactics to imply an official association with that sporting event. And usually the larger, more popular the event, the more often ambush marketing arises. So think about the Olympics. Those Olympic rings are vastly, greatly protected. You're at the beginning of your book. There was an example given of the London Olympics a couple of years ago, and there was a very small local meat shop that was excited about the London Olympics being in their town. And so one of the things that they did in advertising in their window was they set up sausages in the form of the Olympic rings, and the International Olympic Committee was upset. They took issue with it and they made them take it down. Now that might seem very extreme, but when you've got other cases where people are actually using the Olympic rings on t-shirts and creating slogans, it can be considered as ambush marketing. So there's lots of varying views about the appropriateness and ethics in regards to ambush marketing. Typically, ambush marketing in sport takes one of the following forms. It takes a generic phrase or a generic symbol, or what they do is purchase advertising time within the event broadcast itself. They also take a presence in or around the event venue, so they're maybe out there walking around using a phrase. Maybe they're conducting consumer promotions themselves in order to promote their own company. And maybe they're just offering congratulatory messages. Some of these ideas might not seem predatory, but you have to remember ambush marketing is when a company capitalizes on an event, implying that there is some sort of association with that sport event. So that's why this is very important that you, if you want to be a personal business owner, that you research and understand the legality side of sports marketing, because that meat company or that small mom and pop meat shop in London probably wasn't really truly trying to make a ton of money. Maybe they were just really excited about what was happening in London, but it can be considered predatory, and there are legal ramifications that come with it. So that's something out there that we need to be very aware of. So let's talk about the right of publicity and invasion of privacy. The right of privacy protects intrusion on a person's seclusion, misappropriation of someone's name or likeness, or any unreasonable publicity placing a person in a false light. So think about maybe former athletes that all of a sudden have turned on the newest video game, whether it's basketball, whether it's soccer, whether it's football, and all of a sudden they are a character in that video game. That can be considered a right of publicity and an invasion of privacy. The right of publicity really prevents the unauthorized commercial use of a person's name, and so that would be a little bit more appropriate example. There have been a lot of court cases related to sports marketing. There tends to be very blurry lines when it comes to following the right of publicity and invasion of privacy. Again, seek counsel before you start using somebody's famous person's name in your advertising or in your slogan. The next small topic in your book talks about contractual issues involving consumers. And there have been several contractual legal issues that have emerged related to team fans and the purchase of season tickets. You have instances where teams have sued their own season ticket holders for failure to pay. For example, the New England Patriots sued season ticket holders who were in default on their payment plans. It was actually criticized because it was really unclear whether the Patriots sustained any true damages because of the season ticket holders' breach of contract. Another NFL team got smart to that, and the Redskins included a liquidated damages clause into their season ticket holder contract where they could pursue legal ramifications against people that were in default. These teams have to be very careful, though, of the negative publicity that can arise in the process of suing season ticket holders. Sorry, I get tongue-tied frequently. There have also been instances of season ticket holders suing teams and athletics departments for requiring the purchase of a personal seat license or a PSL, or maybe for changing policies about seat location relative to maybe personal donation level. So your book really goes into those examples. Take time to read it. And just simply understand that contractual issues can lead to legal issues if you're not careful to follow what's been put in writing. So the bottom line is make sure that you consider the legal implications, but also public relations when it comes to suing or taking legal action. Promotion law issues. So this is in regards to sweepstakes, contests, lotteries. Those are definitely popular sports marketing promotional tactics to get people involved in order to use them legally. However, sports marketers, again, you have to be aware of the regulations that are involved. In particular, consider the elements of prizes, chance, and consideration. So when we're talking about prize and chance and consideration, we want to understand that sweepstakes, contests, lotteries are all very popular tactics, but if handled improperly, they can have very expensive and also very embarrassing consequences. So let's just very briefly talk about the differences between a lottery, a sweepstakes, and a contest in sports marketing. Typically, lotteries are promotions in which elements of prize, chance, and consideration are present. An organization can legally sponsor a promotional game without violating state lottery laws if they remove one of those particular elements, prize, chance, or consideration, because only states themselves have the legal right to conduct lotteries. Sweepstakes, or like an instant win game, they're promotional tactics. They're designed to encourage product or service sales, but the rules have to clearly state that no purchase is necessary. And I know that some of us have heard, those types of offers before. Contests are typically structured and they eliminate the element of chance by requiring some level of skill or expertise. So if you went to March Madness recently, you saw at the halftime show, they had a couple different college students that were selected to do free throws, or to, they had 30 seconds and they could shoot from anywhere they wanted to on the court to sink a certain number of points. We also have to understand that, once again, not really going into it hardcore because you guys you've heard me say it a couple different times. Seek advice of legal counsel if you are determining to use some sort of promotion in regards to your product or service, so that you can avoid any legal ramifications, legal entanglements that would prevent you maybe from possibly even running your business at all. And then the final issue that your book brings up talks about emergent issues. There are several issues that are coming out recently that deals with sports marketing and the law, and that's the athletes' use of social media, athletes trademarking their own names and slogans, as well as using current and former student athletes' likeness in video games. We kind of talked about that earlier. So as sports marketers, we have to understand that the regulations that govern the commercial use of social media are an area of growing concern. In 2010, the FTC published new guidelines for companies and athletes who were seeking to leverage social media to promote products and services. And this was through something called the Guides Concerning the Use of Endorsements and Testimonials in Advertising. And basically, these new guides really clarify that celebrities, or athletes, or both, they have a duty to disclose their relationships with companies when making endorsements outside the context of traditional advertising, or when an audience wouldn't otherwise expect that a financial connection exists between an athlete and the advertiser. And companies using athletes as an endorsement vehicle, they need to understand and remember, and you do too if you're going to have your own personal business, the underlying rationale of the guides is that consumers have a right to know when they are being subjected to a sales pitch. We've all seen it, we've heard it a million times. Athletes that are sponsored, in surfing, they have their stickers all over the back of their board. They wear their names on their rash guards. They wear the caps if they win the championship and get carried up the beach. The point is making sure that there's a clear distinction between advertisements and non-traditional advertisements out there. Again, do your homework, research the law, know what it means before you venture out there. And that concludes our lecture for Chapter 14. Again, read the activities, read the wrap-up, ask questions in class.